welcome to this YouTube channel of Cyen Cybersecurity. We have a series of interviews with experts on cybersecurity and linked areas. And today we're particularly pleased to have our speaker, Zenner. He is the head of office and policy advisor to Axel Voss, member of the European Parliament here in Brussels. Welcome again, Kai.
Thank you. Thanks for inviting me.
With Kai today, we will discuss AI and cybersecurity in AI. This is triggered by the European legislation, the AI Act, that is still under discussion, recently proposed by European Commission, and which legislation includes cybersecurity rules. Kai is very involved together with his MEP and the European People Party in this legislation. And we would discuss with him what is it about, how the risk-based approach is included, and what it would mean for companies, what are the specific rules. So Kai, can you please wrap up again very shortly, what was your engagement on AI Act and in general in the topic?
Yes, sure. So the jury committee where Axel is coordinator for the EPP group has now a long time addressing AI, especially from a legal perspective. We did 4 own initiative reports in 2019, 2020, and even in the last term, there was an AI resolution. And yeah, unfortunately, we didn't become the lead committee. This, as everyone knows, is now IMCO Liebe, where Axel is now the shadow rapporteur for the EPP group, and he is the rapporteur for the jury opinion.
Okay, so to those of our audience that is not very familiar with the EU jargon, this means he is a very important figure that is basically drafting the amendments and influencing how this AI Act would look at the end after the co-legislation. So the Parliament, the Council have the opportunity to include amendments to this draft before it's adopted and effective at the EU. But when we speak about AI, we know that this is a complex and developing area, right? It is still debatable what really is AI and how we can distinguish it between any kind of machine or encoding software. So what was the biggest challenge for you and for policymakers in legislating the AI?
Yeah, I would name or mention 3 points here. So first of all, and you kind of indicated it already, is the timing. So as we all know, AI is an umbrella term which catches or covers very different types of technologies. And here it's really machine learning and deep learning technologies where the most recent and exciting developments took place. But this makes it also a little bit difficult to regulate it in a smart way, as most of the concrete use cases on the market are still rather unclear. So we are really regulating to some extent in the unknown. And the second point, which is also related to the first point, is the scope. So due to the fact that AI is an umbrella term, let's say it's not really clear what we actually want to regulate. And I said it already in a lot of other panels. In the EP, I would say there are 2 main camps. So one camp, which is really trying to have a very wide definition, an open scope, and kind of rewrite the AI Act to a technology or software act in order to really prevent any misuse or any potential misuse. The second camp, where EPP and others are part of, we really want to focus on the recent second wave of AI. So what I said already, machine learning, deep learning, as here some of the characteristics like opacity, complexity, autonomy could really lead to legal gaps. And the third point, I would say, is the value chain. And this is something that is so far only partly discussed, but I think it's really, really, really tremendously important, because every AI technology involves dozens of researchers, companies that are taking part in the development, in selling, and also using the AI system. But who should have which kind of responsibility? How can we guarantee a fair share of burden? And especially, I would say, there was a really good Economist article 4 weeks ago that we really should take care to not repeat again the same mistakes when it comes to digital platform. So the keyword is here gatekeepers. And already today, there are only a few companies who are really, really able to finance the let's say high level research in, for example, foundation models. So I would say those 3 points make it really, really difficult right now to come up with a smart regulation. And yeah, hopefully we will manage together with the Commission and the Council in the end to do so.
Great. Seems like you're building up on some past experience, and I would be very curious to see how this would work out better now. And building upon is something that we also have seen about cybersecurity in theory. In general, we always refer to risk-based approach. So there is no perfect security. And what we aim to achieve with any regulation or with any implementation measures in companies, this is to somehow to address the risks that we have for our security, and so to find ourselves at acceptable level of the risk. And to a certain extent, this is what the AI Act takes as an objective, setting up a risk-based approach in the sense of dividing the rules according to the risks associated with the AI systems. We see 4 levels, from unacceptable, which is basically banned, we cannot accept any risk linked to that, to low risk, where it's, let's say, less stringent regulation. So could you share more details about the definitions and the use cases in the AI?
Yes, sure. So maybe I start with a statement that the risk-based approach is really key for the EPP in order to be able to accept the Lex Specialis AI. Because again, I think it was already kind of clear in my first comment, we are a little bit skeptical if it's really the right time currently, when it's so early at the development stage of the second wave of AI. But yeah, if there is really a strong risk-based approach going through the whole AI Act, I think EPP can support it. But this would mean that, and now it's becoming a bit tricky because in the impact assessment, there are basically no numbers on that. There is a SEP study which was attached to the impact assessment, and this SEP study from Andrea Render and others was saying that 5 to 15% of all AI systems would fall in the high risk category, and would of course then need to fulfill the high risk obligations from Article 8 to Article 15. Apart from that, as you already mentioned, there is then a small number of AI systems. No one at the moment really knows how much that would be banned, so Article 5, and then another small number of AI systems which would fall under this limited risk category and need to fulfill some transparency obligations. But the vast majority, and this again for us EPP is tremendously important, would be classified as non-risk or no risk, and would not need to fulfill any of the new obligations. The Commission decided against any risk definitions or criteria that you asked for, but really went for this list in Article 5 of the banned use cases, and for example, social scoring is there, and then also for the list in Annex 3 with the high-risk use cases. One example is there the admission to a university that is being performed by an AI system. And actually, we do not find this approach bad, because it's a kind of smart way via delegated act to make swift changes to both lists. So if, for example, there is really an extremely dangerous or potentially dangerous AI system where a lot of misuse could happen, then the Commission could, with the delegated act, which if you are doing it fast, lasts, I would say, 6 months in the whole institutional negotiations, because there's a Parliament and Council can just say yes or no. It's a fast way of addressing recent developments. We as Parliament, and I would say especially there again the EPP, we are rather concerned that in the let's say during the discussions that more and more sectors are added to Annex 3, and also a lot of use cases will be added to Article 5, so the band. And this together, going back to the previous question, if the first camp is succeeding and we have an open scope and an open definition, we really think that then it would definitely not between 5 to 15% AI systems categorized as high risk, but maybe 30, 40, 50% or even more. And this is, of course, something no one should want at the current stage, and it would completely go against the risk-based approach. So this is really something we will fight against, but there I would say majorities, at least in the Parliament, are rather unclear.
I see, but from security, from our experience, when we speak about risk, is not something that we define ahead. So the risk analysis is ongoing process, which also covers not only the life cycle of the system, it also could change, because as you said, if we see that some systems are exploited, so these are the threats, right, and the vulnerabilities. So as long as the dynamics in the environment, the threat landscape changes, also this risk assessment might change, and it could be really difficult and sometimes counterproductive to have this risk assessment set in a legislation, which is, we know, fixed for at least 5 years. It takes time to develop, to implement, then to assess and change. But what do we also debate in the cybersecurity field is the risk assessment and evaluation eventually. Do you take the inherent risk? So this is the risk that is linked to this AI system, for instance, without any other security measures? Or do you take the residual risk, which is basically the evaluation of the inherent risk? What would happen if we don't do anything about this AI system, plus the measures that we have implemented to mitigate the risk, whether those are in the process, whether those are technical measures? And eventually, this would give you the residual risk, which is the actual risk today for everyone involved in the process. I can give you an example that I've heard from the manufacturing sector. What they say specifically for AI system is, okay, we have AI as one of the production components in our production line. So there is a whole line and chain of events until a product is designed, and AI has one specific task in one of those in this chain, provided that there is a check and balances at each stage of the process. And this is also used also in security development. We should really consider these measures and security mitigating measures when we assess what is the level of the risk. So that being said, inherent risk versus residual risk. What is the risk that the AI Act takes, and what is your assessment on this?
Yeah, it's a very good question that is so far not often raised. So we actually criticize the Commission's proposal for an AI Act because they really focus strongly on the inherent risk. If you check the risk assessment in Article 9, but also in Article 7, it's about amending Annex 3, or Article 14 about human oversight when it's necessary, or even similar to GDPR, the Article 71, which is about the fines. Again, there is always a strong focus on inherent risk, and residual risk are often not addressed or almost not addressed, or just a little bit. And we definitely, my boss underlines this all the time, we say that a general assessment really requires that you take into account if the risk is mitigated sufficiently through, for example, appropriate countermeasures, or the so-called built-in fail-safe systems. And this is actually also quite important for us. We should also, or this risk assessment should also address, or at least take a bit into account, if there are any opportunity costs of not using AI at all, because sometimes AI is really a game changer, for example, in surgery or whatsoever. So it's really something that is, for example, reducing the chances of surgery going wrong tremendously. And also what you should also consider is, in general, the magnitude of the benefits of the AI system. And let's say again, we like certain parts of the AI Act, and in general, we would say that the Commission did a good job, but we have this feeling that the whole AI Act focus way too much on the potential risks of AI. And when von der Leyen was talking about Lex Specialis AI, she, in 2019, I think it was, she promised to promote with the legal act innovation in AI, the use of AI, and so on. But in the end, the AI Act proposal has just Article 53 on SMEs and Article 55 is it, and Article 53 on regulatory sandboxes, where it's a little bit about promoting innovation. So we say on this part really that the focus is again too strong on the risk, and you brought up the example from manufacturing and so on. Yeah, this is actually also one thing that we are really concerned about, that there are a lot of different risk assessments in parallel that are kind of overlapping, or at least not they are not really complementary. And this is really something that should be addressed in the negotiations, because I think this is kind of an open issue that that could become really problematic later on.
I understand. And then maybe just to also for our audience to understand what the consequence is. So there are, as we said, different level of systems according to the risk. We have clarified there are some very high risks that are banned straightforward. But what are the rules for the rest of the AI system, and more specifically, what are the cybersecurity relevant requirements that would be applicable if a system is qualified as high level risk?
Yeah, so as we said before, it's really for only for high risk AI systems that are listed in Annex 3 that those high risk obligations from Article 8 to 15 applies. And Article 15 is specifying basically on cybersecurity, but also accuracy, robustness, and so on. And they are saying that the provider of an AI system needs to meet certain, let's say, minimum criteria, or a certain quality level of cybersecurity or cyber resilience, let's call it like this. in this article, it was the ITRE committee which was in lead. I haven't seen there the last versions because the final vote was only, I think, in July, and yeah, I had a lot of jury stuff to do. But let's say there, I think we have between both institutions, so Council and European Parliament, a rather cooperative situation. So I think we will really not put there too many new obligations that are then, for example, being in parallel with NIS, with the Cybersecurity Act, with the Cyber Resilience Act, which is coming soon, and so on. And of course, we have there also a lot of harmonized standards or international standards, ISO standards, and so on. So I would say there it's really, or currently the text that I know is really more about making sure that the provider is fulfilling certain standards on cybersecurity, cyber resilience, but it's not going that much into detail because, again, what I said already, there is already a lot of legislation, but also standards existing, and of course, then it's not necessary to really specify everything in detail again in the AI Act.
This is a good approach, at least for what concerns me. I have seen this approach in other legislation, such as the medical devices regulation, for instance. It's a traditional safety regulation for a very highly regulated sector, where we have an recent update from 2018 on including cybersecurity requirements. But those cybersecurity requirements are just mentioned in one article. And then there's a whole group, Medical Device Corporation Group, which developed very extensive guidelines of what does that mean specifically for medical devices. I hope and assume this would be the same approach once the AI Act is adopted. There would be some sort of expert group, hopefully involving also industry, that would define what specifically is meant and is necessary for this AI systems to include in their cybersecurity program. And I already mentioned the medical device regulation. We have seen also financial sectors, very highly regulated sector, having their digital operation resilience acts. So again, introducing cybersecurity rules for the sector as a whole. How do you see this different sectorial legislation fitting, and in what is the interplay with the AI Act and the cybersecurity requirements? How can we ensure alignment as well?
Yeah, so this is indeed one of our key concerns, let's say, when we are going into the negotiations now, because even though the European Commission is saying that the AI Act in the end is only complementary with regards to the existing EU laws, so you mentioned a few, we need to say here we highly doubt it. So we highly doubt the statement, because we actually found a lot of potential or existing overlaps with laws like GDPR, e-privacy, platform to business, DSA, platform work directive, but also NIS2. And if those overlaps are not fixed, it could really lead to situations. I will bring two examples. So if, for example, the provider of an AI system is at the same time the controller, because he or she is processing personal data and therefore falls under the GDPR, he or she would need to do a risk assessment, Article 9 AI Act, but also in parallel a data protection impact assessment, Article 35 GDPR. Or if there's a security breach, the company would need to notify the competent national authority due to Article 62 AI Act. And if I'm not mistaken, I think there's a similar obligation for provider in NIS2 Article 20, I think. And there basically then the same company would need to notify the AI authority in Germany, for example, but then also the NIS2 authority in Germany. And then basically those two need to interact. And this, of course, doesn't make any sense. It's a lot of red tape and without any added value. And those things, I think, were a little bit overlooked by the Commission, and we now, the co-legislators, should really try to address it. And you mentioned the MDR, and we could also name there the IVDR, because there I would say it's both of them are the clearest cases of legal overlaps that at least I know. Both of them, or at least one and the other, they have different things. They have AI definitions, risk assessments, notification procedures, and so on. And again, what I said already, those are sometimes at least in contradiction with the AI Act. And what is then the legal effect for the health sector? No one really knows. And Annex 2, as you said, has a lot of other sectorial legislation listed. But it's often not clear also with machinery and so on. In the finance sector, there are a lot of potential overlaps, insurance even more, where we really, I think, need to go much more into detail and make sure that if one sector, for example, is already fit for the future and fit for AI, those things should be excluded then from the AI Act. And actually, we did this with our amendments on the MDR, where we said, okay, MDR is listed in Annex 2B, which in the end means that the AI Act is not applicable for systems that fall under the MDR. So this is one of the options to solve it. But again, to summarize, we really need to do more research on it and check in detail what is overlapping, what makes sense, and so on.
You mentioned this amendment for excluding sectors that are already regulated, like MDR. Is that the final text, or this is just a proposal at this point of time?
Yeah, so at the moment it's only a proposal by Axel and MEP Kloon and MEP Eva Madel, so EPP. But I think there is a lot of support from other groups. So chances are good that maybe it passes. I saw similar things or similar actions from the council. So I think there on this part, especially the health sector, did a good job of raising this point. But what I said, the same applies to insurance, to banks, and also to cybersecurity. I mentioned one issue there. We really need to take our time, and I think there is awareness in both co-legislators. So my feeling is we will take this time and really make sure that there are not too many overlaps.
Great. So what we need to do with our followers is to invite you again once the act is published and effective, so that you could walk us through the final decisions. In the meantime, to those of you who are listening, who have an opinion already whether their sector should be included, excluded, don't hesitate to reach out to your MEP, to Kai maybe as well, to other member states if you want to change this in the regulation. Something very interesting also in the regulation, and I think also is the opportunity for it to provide more time for analysis and to fine-tune the regulation, is the so-called regulatory sandboxes. So the AI Act sets these sandboxes as a tool to allow business experiment and explore the innovative products under the supervisory of the regulators. So can you, Kai, tell us what does that mean in practice for businesses and how they can start this procedure or use this option?
Yeah, so this is tricky to answer right now because, well, according to Article 55 in the AI Act proposal of the European Commission, member states should establish 6 months, I think, before the AI Act, is applied already, those regulatory sandboxes. But yeah, the criteria and also the concrete procedures are still really unclear, because especially on this Article 53, there are so many amendments by the European Parliament, by the Council, that I think a lot will change. So the biggest changes were, as many of you know, probably from the French presidency, which added a lot of stuff on testing and so on and so on. So we really cannot say right now how it will look in the end, because it's really up for grabs and it needs to be discussed. I can say a little bit maybe to us, so what we think. We as EPP, we are really pushing forward to not only create so-called physical regulatory sandboxes. So for example, one in Sofia in Bulgaria, but also at least making them hybrid, or maybe from the beginning making them virtual, in order to include more people. Because let's say if, yeah, for example, in Germany, if there is a sandbox in Munich for a startup in the north of Germany, it would be rather complicated to really send some person to Munich for maybe 1 year or longer. So a virtual sandbox via, for example, a secured online platform or something like that could really help to include more players, and especially smaller market players. We also hope that the member states in the end are using as much as possible existing structures, let's say. So for example, the digital innovation hubs, which are what we hear quite well working in a lot of member states. And then it would make sense maybe to yeah, add a side campus at this hub, which is then focusing on AI. Yeah, therefore also connect AI with other areas. So for example, cybersecurity, which probably in a sole regulatory sandbox, AI will not take much of a role. But if you have it really as a digital innovation hub, probably people will just talk with each other, and there's much more cooperation. And from our eyes, it would, or from our side, it would also be rather good if now not every member state is saying, yeah, we make a regulatory sandbox for all AI applications and so on, but instead really focus on certain things that the member state is good in. So for example, the classic example is Estonia with e-governance. So for example, there we could check a little bit how eID and other e-governance applications can be improved by AI, or what I know from my previous job at Konrad Adenauer Foundation, that Romania is very strong in smart farming. So for example, they could have the lead with their regulatory sandbox on AI there. The most important point, and this makes the whole discussion, I guess, also a bit tricky, is how do we foster cooperation among companies? And here the even bigger question is, should non-European companies be allowed to join? We as EPP, as supporter of international trade, international cooperation, are really saying 100% yes. So international companies should be allowed to join. But then, of course, not only with international companies, but also with companies from other member states, or even from the same member state, one big issue is, how do we protect intellectual property rights? How do we protect trade secrets? Are companies really willing to open up on some intellectual property rights and share their knowledge with other companies if they are cooperating on a common project? I think there really we need also to create some incentives, and again give them some safeguards in order to protect their knowledge and so on. And maybe as a last point, I think the question of liability is also tremendously important. So what is happening if in the sandbox, which of course should not be a legal vacuum, but should be a little bit, yeah, it should be allowed to also test some things that are maybe not 100% in line with every regulation out there, but how far are we going there, and what are, for example, our limits when it comes to testing, and the limits, of course, morally, but also legally. So all those questions need to be addressed first before regulatory sandboxes can really be a success story, because what I said, there are really a lot of very, very tricky questions.
I see. I think our viewers now are more aware about the complexities, even if we thought AI is a complex area now, seeing also the regulatory challenges, it becomes even more difficult to grasp how it would happen in practice. But these regulatory sandboxes, they are in a way a sign for an initiative or willingness of regulators to do better, to innovate, to include probably what we used to speak a lot in the past, the better regulation agenda. So do you think this would really improve the regulatory, let's say, approach? Would it be contributing to better regulation? And what else is in the pipeline to make regulation more future-proof and more holistic and efficient in targeting the regulatory objectives?
Yes, so here I have two answers, and one of them I already one is rather negative, but I start with the positive one. Regulatory sandboxes are definitely a really, really good step forward, and we really support them and also other, let's say, for example, public-private partnerships and so on. There are a lot of new regulatory approaches, which are not always saying, okay, we need a new law, otherwise we are not able to address certain issues that we want to address. And let's say this openness is definitely something that is very positive. And there I would agree that we are going in a good direction, that we are, as the legislator and also the Commission, more aware what alternatives are there, and also more aware what other work streams are concentrating on this topic. So as you know, for AI, for example, the OECD is working on it. ISO was just releasing new harmonized standards. Council of Europe is working on it, and so on. And I think there again is a lot of willingness to cooperate, to test also a little bit, and for example, the delegated acts that I was already mentioning when it comes to Annex 3 are also a nice and smart way, I would say, to not spend 5 years for a review of the whole AI Act if there is no need, but then just go with the delegated acts in order to add, for example, certain criteria that are so far missing because there is a new technology development in technologies. But now the second one, more negative one. I would say regarding better regulation, I'm really thinking that there we are moving in a very, very bad direction, because we were talking already about legal overlaps of the AI Act with existing and upcoming laws, and also on governance and enforcement. You see also a lot of problems and overlaps. So I'm not a cybersecurity expert, but when I made an overview what mechanism, enforcement or governance mechanisms are there on EU level, I think I found 7 or even more, and a lot of expert groups and so on, everything overlapping. And again, it's coming always from the same issue, that there's one unit or one DG in the Commission, then there is only 1 or 2 committees in the Parliament, one working group in the Council, and often they are not cooperating enough with other work streams and so on. And also often these work streams are time-wise not in line. And I would say a lot of lessons were not learned from GDPR and other files, where certain things were really not working well, but now we are trying, especially on the enforcement area, we are trying again the same. And let's say also the impact assessment on the AI Act had several gaps. So I was speaking already about the legal overlaps that were almost not covered at all by the impact assessment, but there was also not a lot of talk about the compliance costs. That's rather unclear. And again, I spoke about the CEP study, which at least said how many high-risk AI systems there will be. But this part was completely missing in the impact assessment. And I would even talk here about a general trend that, yeah, the better regulation agenda is kind of dead. For example, the one in, one out principle, no one follows. And DG Justice, unfortunately, remains rather silent because they would be the ones for better regulation. And the scrutiny board, what we could see in the last weeks is completely ignored if they are not approving a file. And I think we can all share the impression that for the Commission, for the Council, for the Parliament, it's often more important that a legislative file is politically needed than that it's legally sound or also practical working. And honestly, I find that this is a disaster for our EU democracy, because we should really make laws that that are necessary, that are legally sound, and so on. And therefore, it's Axel and we are really trying a lot here in the Parliament to fix this as soon as possible, to really bring back the better regulation agenda, to follow and to stick to our own institutional rules and proceedings, and maybe also create new things like independent impact assessments that are maybe also having a different view. And as a general rule, maybe addressing now the final part of your question, as a general rule, I think especially in the digital sector, we should really regulate less, especially at the beginning of a new technology development, and we should also much more concentrate on legal overlaps to really see and check, assess how a new piece is fitting in the whole legal framework of the digital single market, if it makes sense. And if we are deciding to regulate, to really do it strictly principle and risk-based, and really have it through the whole act or the whole regulation, because often there is a stamp like risk-based approach on a file, but then there are a lot of parts in the legislation that are not really risk-based. So because I'm saying all of this because Axel and we are really convinced that innovation only strives if there are not too many bans, not too many restrictions, and that we as a legislator should start to focus more on the potential opportunities, which are tremendous with AI, like smart grid, connected cars, reduce traffic jams, improve supply chains, and so on. There are hundreds of positive cases, but unfortunately, the Parliament especially is just focusing on the risk. And this is really something we feel in the mindset of people, especially in the EU and institutions, needs to change. And then now coming back to the first point, we see, however, that at least there is more, let's say, an open mind when it comes to try out new approaches, different approaches. And then again, if we manage to go back to the better regulation agenda and really follow the rules there, and this combined with trying out new things, then I think we are on a good track. But we really need to fix this better regulation issue.
Yes, very insightful, and I'm glad that there's someone still remembering and following up on this objective, which I think for industries is essential. Kai, there's so much going on and so much you are doing on AI Act and other legislation. Where can our viewers follow your work and how can they support you? Just maybe very short reference.
Yes, sure. So Axel and I, we are always looking for use cases. So for example, if your cybersecurity product would not work very well with some of the high risk obligations, 9 to 15, for example, human oversight doesn't make sense with your service or your product, please send us such a use case. Please also send us use cases of showing that there are positive applications of AI. So for example, AI helping to improve cyber resilience and so on, because going back to my last statement, we really need to show a lot of people here in the parliament that AI is not just creating risks, but also creating opportunities. So please send us those examples via email or to my LinkedIn account or Twitter account or whatsoever. You will find me and Axel everywhere on the internet, and all channels are open, and we really always look forward to read practical experiences and practical feedback on what we are trying to do here.
Thank you very much, Kai. I would like also to mention, you said yourself you did a little research of how legislation is overlapping. I did this together with my intern Ilana Kunkel. We compiled a policy piece which we are publishing now on the review of cybersecurity legislation. So what are the different pieces coming from specific or sectorial legislation, how they interplay, but most importantly, what are the gaps? Because sometimes doing too much, you forget, okay, what was the objective that we are after and how to make it more effective as policy recommendations. So stay tuned. We would publish this and promote it and maybe also organize on this YouTube channel presentation. So subscribe down there to follow us. And I wish Kai a success in their work, in their policy work. I hope many of our viewers would send you case studies, positive, as well as highlighting some issues so that you could have your work supported with facts. Thank you so much, Kai, and to everyone who is here with us.
Thank you.